on this morning's Ag Issues program. A pleasure to bring on to the program, as always, Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Doing fine, thanks.
Well, a very busy latter part of last week for you, as we finally got the decision or opinion, in this case from the U.S. Supreme Court in the Sackett v. EPA case, and basically it was in favor of the Sacketts for this particular case, but of course there's a lot of background that people might be unfamiliar with this couple from Idaho, and why agriculture had been very, very closely watching what the opinion of this case would be.
Yeah, that's right. This case is vitally important to agriculture, and what it involved, even though these people are not farmers themselves, the implications are huge for agriculture as well as all other rural landowners. But the case involved the Sacketts, who had bought property near Priest Lake, Idaho. Now, to give you kind of a geographical picture in your mind where that's at, there's that peninsula that is the narrow peninsula that's the far northern part of Idaho, not too far from the Canadian border, and they're down a bit from the Canadian border, but they're up in that narrow peninsula. So basically, you would go to, say, if people are familiar with Spokane, it's north and east of Spokane in Idaho. Coeur d'Alene, within an hour to the north of Coeur d'Alene, Idaho. So it's way up north. And so they buy this lot. It's a beautiful place. They started to backfill the lot with dirt to prepare to put their home on it. And then the EPA came in and said, well, you have to stop because your dry lot that is 150 yards from the lake is a water of the United States. Get this, your dry lot is a navigable water of the United States. Because it was near a ditch that fed into a creek that fed into Priest Lake, which itself was a navigable intrastate lake. And that backfilling, therefore, violated the dredge and fill requirements of Section 404 of the Clean Water Act. And if they didn't stop, EPA was going to hit them with penalties of $40,000 per day. And this case actually made two trips to the United States Supreme Court. What we saw last week was the second and I think what will be the last opinion of the Supreme Court on this one. But initially, the Sacketts tried to appeal the order that EPA gave them to stop backfilling, saying, it's not a wetland, we're not in violation. And the EPA said, well, you can't sue us because that's not a final determination. And so the Sacketts said, well, make a final determination. Say that it's a wetland. No, we don't want to make a final determination because if you do that, then you can challenge us on that. So it's just going to prevent you from putting any fill in this lot, and you can't do anything about that. So they were stuck, and so they sued on that. They lost in the trial court. They lost in the appellate court. They went to the Supreme Court a number of years ago on that, and the Supreme Court said 9-0. EPA, you've got to make a final order. They can appeal from that, and these pre-enforcement, non-enforcement orders are appealable. So they won that round, and so EPA had to say, okay, yes, formally it is a wetland. So then the Sackett said, all right, we challenge that. So they ended up going through the legal system all the way again. They lost in the trial court. They lost in the Ninth Circuit. They get to the Supreme Court, and last week, 9-0, again, the U.S. Supreme Court said, that's not a wetland.
Wow. So that's the start of all this. But of course,
yeah, and keep in mind, Greg, they bought this property in 2004, so this has been going on for almost 2 decades.
So a part of this decision, a 9-0 decision, as you talked about, was there a key point in all this? And then the second part of that, Roger, is as anyone in agriculture, anyone who's listening right now, what does this mean for EPA's 2023 wood rule?
Yeah, and that is the key question on this. And the key point, the court was 9-0 in saying that the way that an isolated wetland or an adjacent wetland, an adjacent property is deemed to be a navigable water of the United States is not to be determined by the significant nexus test. And that's key because the 2023 WOTUS rule is tied to the significant nexus test. And I think in agriculture, we've all heard about that. That was in the Obama rule. The Trump rule got rid of that and said, no, you've got to have a continuous flow from a tract or from an isolated wetland to a navigable water body to have a jurisdictional wetland under the Clean Water Act. And so the Supreme Court said, all right, 9-0, they all agreed, significant test is no good. And remember how that happened in Sackett's case was that their lot was near a ditch that fed into a creek that fed into the lake. And so it's kind of this wrist is connected to the elbow, is connected to the shoulder, and somehow that's connected to the knee and to the ankle. And the court said, no, we're not doing that. That's ridiculous. We're not going through that. And so all 9 of them, and that's the most amazing part of the case to me. They all agreed to trash the significant nexus test. Then you had 5. And this is the majority opinion, and it was Justices Alito, Chief Justice Roberts, Justice Thomas, Justice Gorsuch, and Justice Barrett, that then pared back the expansive EPA regulatory authority under the Clean Water Act and replaced that significant nexus test with a new standard. And actually, it's an old standard. It was the Scalia standard, the standard set forth by Justice Scalia in his plurality opinion in what's known as the Rapinos case in 2006. Now, that didn't become the lead opinion of that case that lower case courts would follow. That was the Kennedy test because that was decided on more narrower grounds. And so there's a legal principle that says when the court's all fractured like that, you use the opinion that's the most narrow, and that became the Kennedy test. But there was that Scalia test sitting there saying that, no, the term waters in the statute refers to waters. See, it kind of makes sense. Water means it's wet, and that refers to only geological features that are streams, oceans, rivers, and lakes, and to adjacent wetlands, and this is the key, that are indistinguishable from those bodies of water due to a continuous surface connection. That is the absolute key on this that's going to be very important for agriculture because EPA or the Corps under the Clean Water Act won't have jurisdiction over your private property unless they establish that the adjacent water body is a relatively permanent body of water connected to an interstate navigable water, and that wet area has a continuous surface connection with water that makes it more difficult or makes it very difficult to determine where the water ends and the wetland begins. Now, you had 4 justices that dissented, but that's the dissent. It's not really relevant. But your question in terms of what this means for the 2023 WOTUS rule, the EPA's WOTUS rule that they just put out this spring, that's deader than a doornail. They're going to have to go back and redo that. So it was kind of a waste of time, waste of money for the agency to do that because the Supreme Court has completely wiped it out.
One final question before we go to a break. What about any deference to the EPA and also to the Army Corps of Engineers?
Well, that's really interesting because normally the courts defer to the judgment of federal regulatory agencies on matters such as this, and there wasn't a single mention, Greg, of deference by any of the justices at all. So they're basically saying here that the scope of an agency's authority is not the sort of question upon which courts will defer. And I think that's a very nice setup for another case that just about 3 weeks ago they agreed to hear. And that is a case that will deal squarely with what's known as Chevron deference. And that's coming up. It's probably going to be argued this fall. We'll have an opinion on it next year. And that whole issue of deference that's been out there for 40 years almost, which has been a major hurdle for farmers and ranchers challenging government regulatory action on their property, that may be gone. But this case sets it up really well. None of them talked about deference in this case at all. They just took the bull by the horn and said, look, that's the wrong test. You don't like this test, then go back to Congress and have them rewrite a rule.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is our guest. And, of course, breaking down some of the Supreme Court decision from Thursday concerning the Sackett v. EPA case having to do with the Waters of the United States rules and how that is going to affect agriculture as far as the rules are concerned. And Roger, let me ask, will the court's decision that they have made, is this going to have a negative impact on water quality?
I don't think that's very likely at all. Now, while the decision does cut back on the definition of the waters of the United States for purposes of the entire Clean Water Act, the decision won't necessarily have the same effect on traditional pollution control efforts, because 3 years ago, in the summer of I think it was April of 2020, the Supreme Court decided a case out of Hawaii. And in that case, the court upheld a broad interpretation of what constitutes a discharge of pollutants, such that if you have some activities that result in contamination of waters that are regulated under the Clean Water Act, they may be subject to regulation, even if they occur on land where that land itself is not subject to Clean Water Act regulation. Plus, you have existing state and local regulation that still applies. In this case, doesn't do anything with respect to that. So in many places, with respect to the state and local regulations, they're significant, and many of those were in place well before the EPA and the Corps got involved in this whole issue back in the 1970s. So I don't think there's likely to have any negative impact on water quality at all. You've got a couple of different issues that really, this is the problem with the statute. As Congress created it. Navigability goes back to the Rivers and Harbors Act back in the 1890s and some amendments associated with that. And so you have the Corps that's responsible for making sure that rivers are dredged for purposes of commerce. And you don't want to put rocks and dirt in rivers. That's what they're concerned about, because it might affect navigability. And then they threw in the EPA and said, well, water pollution's an issue. And so they kind of threw those same concepts together and has created the issue here. So what the court is dealing with here, we could still end up in a situation where you've got a discharge issue that the Corps is concerned about, and you could have contamination of waters that they're regulating, even if it occurs on lands that itself now, because of what the Supreme Court has said, is not subject to regulation. So long answer, but long explanation. The short answer is no. I don't think it's very likely to have any impact on water quality.
So as we look at this from an agricultural point of view, with what they have to do or will have to eventually redo with the 2023 WOTUS rule, but as we look at it as a broad scope, what are we seeing, or what are the implications for agriculture?
Well, you're basically back to the Trump rule, the National Water Protection Rule. So streams and ditches and private waters that don't have a continuous surface connection to navigable waters won't be subject to the Clean Water Act. And it'll make it more difficult for the federal agencies to assert regulatory authority over private land under the Clean Water Act. And so that eliminates federal control under the Clean Water Act over such things as private ponds, ditches, and streams where there's no continuous flow into a water of the United States. And, the real kicker in this thing, Greg, is that had EPA not been so belligerent with the Sacketts and backed them into a corner where the only option they had was to sue, we'd still have the significant nexus test. So agriculture's got a lot to, in this instance, ironically, thank EPA for being so bullheaded with the Sacketts. They lost their broad regulatory authority, but I think that's absolutely hilarious. But you think of western Kansas and the ephemeral streams that are out there. You think of prairie pothole region in the upper Midwest and the upper Plains. That jurisdictional, those are no longer jurisdictional wetlands under the Supreme Court's guidance here, under their ruling.
So what does this, or differences of, because we have seen, of course, swamp buster rules come into play in this, or associated with this, maybe is a better way to put it.
Yeah, farmers that are in the farm programs are also subject to the swamp buster rules. And so a wetland there is defined differently than it is under the Clean Water Act. And so you've got two separate definitions to deal with. And the one at issue in Sackett involves waters of the United States, which is contained in one part of the U.S. Code, and that that gives us the definition of what a navigable water is, and the court has narrowed the jurisdiction with respect to those. But Swamp Buster involves the definition of a wetland contained in an entirely separate part of the U.S. Code. So there are two definitions of a wetland, and the Swamp Buster definition is you've got to have three characteristics. You have to have hydric soils, a hydrophytic vegetation, and inundation for at least 2 weeks. And that's what your definition of a wetland is for purposes of Swamp Buster. And if you have that, then you can't produce a crop on that. If you do, you're going to lose your subsidies. So this all means that farmers may not have a wetland that the EPA or the Corps can regulate under the Clean Water Act, but you still might have a wetland that can't be farmed without losing farm program benefits.
One thing we do want to mention, too, of course, Roger, as you travel throughout the summer, you have one of your summer tax seminars that's going to take place in Coeur d'Alene, Idaho, August the 7th through the 8th. But understand that the lead counsel in the Sackett v. EPA case is going to be there at this summer's tax seminar in Coeur d'Alene.
Right, and this is more than just my normal tax, farm tax, and estate and business planning conference. This is two conferences in one. We have two separate tracks running. We have the normal, for 2 days, we have the normal farm income tax, farm estate and business planning track, but running at the same time, we have 2 days of agricultural law topics. Same building, adjacent banquet rooms is where we're at. And in the ag law track, and I'll be speaking on both of these tracks, now not obviously staggered times, but on the ag law track, Damian Schiff with the Pacific Legal Foundation, who was the lead counsel for the Sacketts and just won this case, he'll be speaking for an hour about the case, and we have a reception on Monday evening at the end of the first day, and we're hopeful that the Sacketts themselves can come down for the reception. This is also available online for people that can't get out to Coeur d'Alene. If you're interested in that, registration opens this Friday. You can find it on my website, and K-State will be putting information out about it also. And if you can't join us in person, it may be something that, at least that portion, would interest producers to hear Damian Schiff talk about the case and the implications for agriculture. That's the way I want him to focus his discussion. Even though, again, the Sacketts were not farmers, it has major implications for producers all across the country. But that's on August 7 and 8 in Coeur d'Alene, Idaho, as well as online.
And everything we talked about today in much further explanation can also be found on your website?
Yeah, if people are having trouble sleeping, they can find about a 5,000-word discussion of this detailed piece from my blog, and that is washburnlaw.edu/WALTR, and later today I'll also send that over to K-State, so it'll be posted on the Ag Manager website, probably tomorrow.
Okay. Sounds good. Roger, hey, I very much appreciate you joining us today to talk about what we've all been waiting for throughout 2023, and we'll go from there, and I'm sure we'll have further updates on this as things develop, so to speak.
Thank you, Greg. I'm glad it was good news to share this time.
Yeah, absolutely. Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, has been our guest on the Ag Issues program here on 580 WIBW.